Judge Cornelius Thornton raised his gavel at precisely 3:47 p.m. on November 12, 1903, pronouncing sentence on a man who wouldn't commit his crime for another 6 weeks. Thomas Henley. Judge Thornton declared from his bench in Boston Municipal Court, "I hereby sentence you to 10 years hard labor for the murder of Catherine Walsh, which you will commit on December 23, 1903, at approximately 8:15 p.m., using a candlestick in her parlor on Beacon Street." The defendant, who had been arrested that morning for public intoxication, stared in confusion at the judge, who was convicting him of a murder that existed only in judicial prophecy. For 8 months, Judge Thornton had been issuing similar sentences for future crimes, with a conviction rate that approached 100% accuracy once the predicted offenses actually occurred. The phenomenon had begun after Judge Thornton purchased a peculiar legal library from the estate of Dr. Simon Blackthorne, a Harvard law professor who had died while researching what he called temporal jurisprudence, the application of legal principles to crimes that transcended normal chronological boundaries. Judge Cornelius Thornton had served on Boston's municipal bench for 15 years, earning a reputation for fair but firm justice that served the city's growing immigrant population. His courtroom on Court Street handled the routine criminal matters that kept Boston's legal system functioning: theft, assault, public intoxication, and the various misdemeanors that arose from urban poverty and cultural conflict. Thornton prided himself on thorough legal research and precise application of Massachusetts law, qualities that had earned him respect from both prosecutors and defense attorneys. The transformation in Judge Thornton's judicial methods began in March 1903, when he attended an estate auction at Dr. Simon Blackthorne's Beacon Hill residence. The professor had been found dead in his study, surrounded by law books that contained annotations predicting future legal cases and court decisions. University officials couldn't explain the circumstances of Dr. Blackthorne's death, but they were eager to dispose of his personal library, which contained what they considered to be the deranged writings of a scholar who had lost touch with legal reality. Most attendees at the auction avoided Dr. Blackthorne's legal collection, perhaps intimidated by the professor's reputation for controversial theories about the relationship between law and time. Judge Thornton saw only an opportunity to acquire rare legal texts and judicial commentaries that would enhance his own legal scholarship. He purchased the entire library for $18, including several manuscripts that Dr. Blackthorne had been writing about temporal applications of criminal law. The first indication that something was wrong came when Judge Thornton began reading Dr. Blackthorne's personal journals in his chambers after court sessions. The professor's writing described a legal philosophy based on the premise that justice could be more effectively served by punishing criminals before they committed their offenses, rather than waiting for crimes to occur and then attempting to undo their harmful consequences through post facto punishment. Dr. Blackthorne's temporal jurisprudence theory proposed that properly trained judges could develop the ability to perceive future criminal activity through careful observation of behavioral patterns, social conditions, and what he called pre-criminal resonance, subtle signs that indicated when individuals were approaching the commission of serious offenses. By intervening before crimes occurred, the legal system could prevent harm to victims, while still maintaining appropriate punishment for criminal intent. The professor's manuscripts included detailed instructions for developing precognitive judicial abilities through meditation techniques, dietary modifications, and specific arrangements of legal texts that would supposedly enhance a judge's sensitivity to temporal legal patterns. Dr. Blackthorne claimed to have successfully tested his methods by predicting and preventing several crimes in Cambridge during the months before his death. Despite his skepticism about Dr. Blackthorne's supernatural claims, Judge Thornton found himself following the professor's instructions out of curiosity about their potential practical applications. He began arranging his law books according to Dr. Blackthorne's specifications, adjusting his daily routine to match the professor's recommendations, and practicing the meditation techniques that were supposed to enhance temporal legal perception. The first precognitive experience occurred on March 28, 1903, when Judge Thornton suddenly experienced vivid visions of a robbery that would take place at Murphy's hardware store on April 3rd. The vision included specific details about the time, method, and perpetrator of the crime, along with clear images of evidence that would be found at the scene. Judge Thornton initially dismissed the experience as imagination or wishful thinking, but when April 3rd arrived, the robbery occurred exactly as he had envisioned. This led Judge Thornton to begin experimenting with pre-crime adjudication in carefully selected cases where he felt confident about his temporal perceptions. He would sentence defendants for minor existing charges while secretly documenting his predictions about future crimes they would commit. When the predicted offenses occurred exactly as he had foreseen, Judge Thornton became convinced that Dr. Blackthorne's temporal jurisprudence theories were scientifically valid. The Thomas Henley case represented Judge Thornton's first attempt at public pre-crime sentencing, where he openly convicted a defendant for a murder that hadn't yet occurred. Henley had been arrested for public intoxication, but during the hearing, Judge Thornton experienced an overwhelming vision of Henley committing murder 6 weeks later. Rather than simply sentencing Henley for intoxication, Judge Thornton decided to prevent the future murder by incarcerating Henley before he could commit the crime. The legal community's reaction to Judge Thornton's pre-crime conviction was immediate and intense. Defense attorneys demanded appeals based on the impossibility of convicting someone for crimes they hadn't committed. Prosecutors were unsure whether to support convictions that couldn't be based on existing evidence. Legal scholars debated whether temporal jurisprudence represented innovative crime prevention or fundamental violation of due process rights. But Judge Thornton's precognitive abilities proved remarkably accurate. When December 23rd arrived, and Thomas Henley remained in prison, Catherine Walsh continued her normal activities, unaware that she had supposedly been saved from murder. Henley's incarceration had indeed prevented the crime that Judge Thornton had predicted, validating the effectiveness of pre-crime intervention, while raising profound questions about justice, free will, and the nature of criminal responsibility. Before I continue with the revelation that transformed Judge Thornton's pre-crime court into the center of a constitutional crisis that would reshape American law, I need to know you're prepared for this journey into judicial impossibility. If you've ever been punished for something you hadn't yet done, or if you've witnessed justice being applied based on predictions rather than evidence, write future justice in the comments along with your city. Subscribe now, because what Judge Thornton discovered about the true source of his precognitive abilities will challenge everything you thought you knew about law, order, and the prevention of crime. Judge Thornton's success with pre-crime convictions attracted attention from legal authorities throughout Massachusetts and beyond. Harvard Law School professors traveled to Boston to observe his courtroom procedures and attempt to understand the methods he was using to predict future criminal activity. The Massachusetts Attorney General's office opened an investigation into the constitutionality of convicting defendants for crimes that hadn't occurred. But the most significant attention came from defendants who had been convicted of future crimes and their families, who organized legal challenges that questioned the fundamental principles underlying American jurisprudence. The case of People v. Henley became a landmark constitutional case that addressed whether courts had authority to punish individuals for crimes they intended to commit but hadn't yet carried out. Judge Thornton's defense of his pre-crime methods was based on Dr. Blackthorne's temporal jurisprudence theory, which argued that criminal intent was equivalent to criminal action when viewed from the proper temporal perspective. He claimed that traditional law enforcement was fundamentally reactive, allowing harm to occur before intervening, while pre-crime adjudication was proactively protective, preventing harm from occurring in the first place. The judge's arguments were supported by his increasingly accurate predictions about future criminal activity throughout Boston. During the 8 months following the Henley conviction, Judge Thornton successfully predicted and prevented 17 additional serious crimes, including murders, robberies, and assaults that would have caused significant harm to innocent victims. But Judge Thornton's investigation into the source of his precognitive abilities led him to disturbing discoveries about Dr. Simon Blackthorne's research methods and the true nature of temporal jurisprudence. The professor's personal papers revealed that his ability to predict future crimes wasn't based on supernatural perception or advanced legal theory. It was based on systematic observation and manipulation of criminal behavior patterns throughout Boston. Dr. Blackthorne had been working with a network of informants, police officers, and social workers who provided detailed reports about individuals who were likely to commit crimes based on their economic circumstances, personal relationships, and psychological profiles. The professor had used this information to create detailed predictions about when and how specific crimes would occur, then tested his theories by intervening to prevent or facilitate the predicted offenses. More disturbing, Dr. Blackthorne's research had involved actively encouraging some individuals to commit crimes in order to test his ability to predict and prevent criminal behavior. The professor had been manipulating social and economic conditions to create circumstances that would drive vulnerable people toward criminal activity, then documenting whether his interventions could successfully prevent the crimes he had helped orchestrate. Judge Thornton realized that his precognitive abilities weren't supernatural gifts or enhanced judicial perception. They were the result of inheriting Dr. Blackthorne's criminal manipulation network and unconsciously continuing the professor's experimental program. The informants and agents who had worked with Dr. Blackthorne were now providing Judge Thornton with information that made his crime predictions appear impossibly accurate. But the network that Judge Thornton had inherited was more extensive and sophisticated than Dr. Blackthorne's personal papers had indicated. The judge's investigation revealed that temporal jurisprudence research was being conducted in multiple cities throughout the United States, with judges, prosecutors, and law enforcement officials participating in coordinated experiments designed to test the effectiveness of precrime intervention methods. The research network included federal government agencies that were interested in developing precrime capabilities for national security purposes. Judge Thornton learned that his precrime court was serving as a testing ground for legal and administrative procedures that could eventually be applied to prevent political crimes, espionage, and other offenses that threatened government stability. But the most shocking discovery was that the temporal jurisprudence network was also being used to facilitate crimes rather than prevent them. Judges and law enforcement officials who participated in the research program could use their knowledge of future criminal activity to ensure that specific crimes occurred when and where they would serve particular political or economic interests. Judge Thornton realized that his precrime convictions weren't just preventing individual criminal acts. They were part of a comprehensive system for controlling crime rates, victim selection, and law enforcement priorities according to political and social objectives that he didn't fully understand. His judicial decisions were being guided by interests that viewed crime prevention as a tool for social engineering rather than public safety. This discovery forced Judge Thornton to confront the possibility that his precrime interventions weren't protecting innocent people from criminal victimization. They were protecting specific people while ensuring that criminal activity continued in ways that served the research network's experimental and political goals. By preventing some crimes, he might be enabling others that were considered more useful for temporal jurisprudence research. The moral complexity of Judge Thornton's situation increased when he learned that several of the defendants he had convicted for future crimes had been deliberately manipulated into criminal behavior by agents working for the temporal jurisprudence network. Thomas Henley's planned murder of Catherine Walsh had been orchestrated by researchers who wanted to test whether precrime intervention could successfully prevent violent crimes that were artificially induced rather than naturally occurring. This revelation meant that Judge Thornton's precrime convictions weren't preventing naturally occurring criminal behavior. They were interrupting experimental criminal scenarios that had been created specifically to test temporal jurisprudence methods. He was punishing people for crimes they had been manipulated into planning by the same research network that was providing him with the information needed to predict and prevent those crimes. But Judge Thornton also discovered that refusing to participate in the temporal jurisprudence research would have consequences that extended far beyond his own career and reputation. The network had invested considerable resources in developing precrime capabilities, and wasn't willing to allow individual judges to compromise their research by exposing or discontinuing experimental programs. The judge learned that Dr. Simon Blackthorne's death hadn't been from natural causes. The professor had been murdered when he attempted to withdraw from the temporal jurisprudence research and expose the network's manipulation of criminal behavior. Other judges and law enforcement officials who had tried to leave the program had experienced similar fates, their deaths disguised as accidents or suicides. Judge Thornton realized that his participation in precrime adjudication had made him a valuable but expendable asset in a research program that prioritized experimental objectives over individual rights or public safety. The network would continue using him as long as his precrime court produced useful data, but would eliminate him if he became a threat to their operations. This understanding transformed Judge Thornton's precrime court from an innovative approach to criminal justice into a tool for systematic violation of constitutional rights and manipulation of criminal behavior. Every conviction he issued was supporting research that treated human beings as experimental subjects whose lives could be manipulated to serve scientific and political objectives. The weight of this knowledge led Judge Thornton to begin planning his own escape from the temporal jurisprudence network, despite the obvious dangers involved. He started secretly documenting the network's operations, gathering evidence that could expose the research program, while taking precautions to protect himself from the same fate that had befallen Dr. Blackthorne. But Judge Thornton's investigation revealed that the temporal jurisprudence network had infiltrated American legal institutions more extensively than he had imagined. Federal courts, state supreme courts, and even the United States Supreme Court included justices who were participating in precrime research or being influenced by temporal jurisprudence theories in their legal decisions. The network's influence on American jurisprudence was creating systematic changes in legal philosophy that prioritized crime prevention over individual rights, government authority over constitutional limitations, and experimental research over traditional legal principles. The precrime court in Boston was just one component of a comprehensive effort to transform American law according to temporal jurisprudence theories. Judge Thornton realized that exposing the precrime research network would require more than simply revealing its operations in Boston, and it would require challenging fundamental changes in American legal philosophy that were being implemented through coordinated influence on judges, prosecutors, and lawmakers throughout the country. The complexity of this challenge was increased by the fact that many participants in the temporal jurisprudence network genuinely believed they were improving public safety and advancing legal science through their research. They had convinced themselves that manipulating criminal behavior and violating constitutional rights were justified by the prevention of future crimes and the development of more effective law enforcement methods. But Judge Thornton's experience with precrime adjudication had taught him that the most dangerous threats to justice often came from people who believed they were serving justice through methods that violated its fundamental principles. The temporal jurisprudence network represented the same authoritarianism that American constitutional law had been designed to prevent, disguised as scientific progress and public safety innovation. On December 22, 1903, 9 days before Thomas Henley's predicted murder date, Judge Thornton made his decision to expose the temporal jurisprudence network, despite the personal consequences he would face. He had gathered sufficient evidence to demonstrate that precrime adjudication was based on criminal manipulation rather than supernatural perception, and that the research network was systematically violating constitutional rights in pursuit of experimental objectives. Judge Thornton's exposure of the precrime research network created the largest constitutional crisis in American legal history up to that point. Congressional investigations revealed that temporal jurisprudence research had influenced legal decisions in over 20 states and had involved coordination between federal agencies, state governments, and academic institutions that had never been subject to democratic oversight or constitutional limitation. The investigations also revealed that the network's manipulation of criminal behavior had directly caused hundreds of crimes that wouldn't have occurred without experimental intervention. People had been murdered, robbed, and assaulted because temporal jurisprudence researchers needed to test their crime prediction and prevention methods using artificially created criminal scenarios. But the most significant impact of Judge Thornton's revelation was the establishment of constitutional precedents that prohibited law enforcement from punishing individuals for crimes they hadn't committed, regardless of the certainty that those crimes would occur in the future. The Supreme Court ruling in Henley v. Massachusetts established that criminal justice must be based on actual criminal acts rather than predictions about future behavior. The Temporal Jurisprudence Research Network was dismantled through federal prosecutions that resulted in criminal convictions for hundreds of judges, prosecutors, law enforcement officials, and researchers who had participated in precrime experimentation. The cases established legal precedents for protecting constitutional rights against scientific research that violated individual liberties in the name of public safety. Judge Cornelius Thornton was removed from the bench but avoided criminal prosecution in exchange for his cooperation with federal investigations. He spent the remainder of his career as a legal scholar, specializing in constitutional protections against government overreach, using his experience with temporal jurisprudence to educate lawyers and judges about the dangers of sacrificing individual rights to achieve seemingly beneficial social outcomes. Thomas Henley was released from prison on December 24, 1903, having served 9 months for a murder he never committed. He lived peacefully for the rest of his life, never showing any inclination toward the violence that Judge Thornton had predicted. Catherine Walsh, whom Henley had supposedly been destined to murder, lived until 1954, dying peacefully in her sleep at age 87. The precrime court case became a foundational example in American legal education, demonstrating how technological and scientific innovations could be used to justify violations of constitutional rights that would otherwise be recognized as fundamentally wrong. Law students continue to study Judge Thornton's experience as a cautionary example of how good intentions could be perverted to serve authoritarian objectives. Modern legal scholars studying the temporal jurisprudence case have found evidence that similar precrime research programs may have been attempted in other countries during the early 20th century, suggesting that the manipulation of criminal behavior for experimental purposes was an international phenomenon associated with the development of modern social science and government administration. The case also established important precedents for protecting individual rights against predictive technologies that claim to identify future criminal behavior. Legal principles developed in response to Judge Thornton's precrime court continue to influence contemporary debates about predictive policing, surveillance technology, and the use of artificial intelligence in criminal justice systems. If this story has made you more aware of how scientific research and technological innovation can be used to justify violations of constitutional rights, please share it with others who work in law enforcement, criminal justice, or government administration. Subscribe for more historical cases where individual courage exposed systematic violations of human rights that were disguised as legitimate institutional activities. Before you go, take a moment to consider, are there policies, procedures, or research programs in your community that claim to prevent harm, but haven't been subject to appropriate oversight or constitutional scrutiny? Judge Thornton's experience with pre-crime adjudication reminds us that the most dangerous threats to individual rights often come from institutions that claim to be protecting public safety through innovative methods. Remember, Judge Thornton's most important insight wasn't about temporal jurisprudence or precognitive abilities. It was about the responsibility that comes with institutional authority. When you have the power to make decisions that affect other people's lives, you also have an obligation to ensure that your decisions are based on principles that respect human dignity rather than experimental objectives or institutional convenience. Next week, we'll explore another case where someone discovered that their professional expertise was being used to facilitate systematic violations of individual rights that were disguised as legitimate institutional activities. Until then, remember that the most important questions aren't always about whether something works or achieves its stated objectives, but about whether it treats human beings with the respect and dignity that constitutional principles are designed to protect.